Welcome everyone to this MGAA even market briefing. Thank you all for joining us. I do appreciate that we have some rare nice weather, so it is appreciated that you're staying inside to have a listen and learn more about non-financial misconduct and an update on employment law. So a little bit of housekeeping first. Anyone who's attended these before, you'll be familiar with the bits and pieces I'll go through. So just a reminder to keep microphones and cameras off, as it helps us in terms of lowering the risk of any technical issues, and also helps with the recording. And also to mention that we are recording, so that will mean that you'll get a link to this and a copy of the slides. So if you want to review anything, you'll be able to, and you will also be able to, yes, pass on the link if you want to any colleagues. Also, another quick polite request: if you are tempted or have activated any AI note-taking bot software, I'm not entirely sure what the appropriate name is for them. If you could deactivate them, please, because we don't have the required permission from everyone attending. So that's all my nice polite requests. In terms of asking questions, we encourage you, please, yes, ask as many questions as you want. Add them into the chat as we're going along. What we're going to do, I'll say I will disappear off camera soon. What Ingrid will be doing is go through the non-financial misconduct part of the presentation, cover questions on that, and then move on to the employment law update. So we'll have sort of two Q&As potentially. So yes, add the questions in as they come to mind into the chat. And final reminder, just to say that the session is accredited for CPD by the CII, so you are able to record your time spent on your CPD logs. So that leaves me to introduce Ingrid and today's market briefing on non-financial misconduct and an employment law update. So over to you, Ingrid.
Well, thanks very much, Alison, and welcome to you all for this afternoon session. For some of you who don't know me or maybe weren't at the last session, my name's Ingrid McGee. I'm a partner based up in Glasgow. You might tell from the accent. I have been specialising in employment law for nearly 20 years, probably over 20 years now, but I always say after 10 years, everything's a blur, quite frankly. I deal with everything from the contentious to the non-contentious side of employment legal issues and problems that employers face. So today what we are focusing on, as Alison said, is the non-financial misconduct aspects within employment, and again some updates around the Employment Rights Bill, which I did discuss at the last session, but there has been some movement, and for those who weren't there, perhaps just a good opportunity to have a recap around all of that. So as Alison mentioned, this is CPD. So again, in terms of the learning objectives, we've got here that by the end of it, you'll be able to explain the impact of non-financial misconduct in employment. You'll be able to describe how to conduct investigations into non-financial misconduct. And again, there'll be an outline of the most recent updates on the Employment Rights Bill. Don't worry, there's no test at the end of this. It's very much a listen and learn session. And again, an opportunity to ask questions at the end of each session as well. So we'll get cracking, because I understand we've got a set amount of time this afternoon. So I've got my slides all over, so in case I'm not looking directly at you, that's the reason why. So I suppose firstly, the good place to start is, what is financial misconduct? And obviously it covers behaviours that don't involve financial issues or fraud. So again, these can include aspects like bullying, harassment, discrimination, inappropriate behaviour, and criminal conduct outside work, which we will discuss. But I think the main thing to understand around all of this is that obviously the nature of your work, financial aspects and fraud are absolutely paramount within the business and within the organisations that you work in. But again, there are non-financial misconduct issues that are just as serious as well, that would need to be taken into consideration and acted upon appropriately and reasonably by businesses and employers if there are any allegations in respect of those as well. So in terms of understanding one of the foundations, obviously we are dealing with the employee's right to privacy, and It's not something that crops up that much, but again, I think it's a good opportunity today to understand what those rights are. So under Article 8 of the Human Rights Act, employees have the right to a private life. And again, employers must ensure that any action they take is fair and reasonable and proportionate. And the government also intends to publish a code of practice for employers on the right to disconnect. Now, that was something that was featured in the Employment Rights Bill, but I think what they're going to do is rather than make that law, they're going to have that by way of a code of practice. So again, keep an eye out for that as and when that comes out as well. In respect of some of the general principles, again, depending on what your role is within the business, you might be a manager, you might be part of the senior management team, who might have to deal with these aspects within an employment capacity. So again, whenever we are dealing with allegations of misconduct, then you normally ask yourself, does the behaviour in question genuinely impact the business or its culture? But also, is it fundamentally an issue that we need to address? And again, disciplining an employee for conduct that has no clear effect on the company could also lead to legal disputes in respect of unfair dismissal claims. And again, there's got to be a really clear link between the employee's conduct and its impact on the company's interests as well. So they're just some of the aspects that you need to be aware of if you are to be conducting a disciplinary process or an investigation as part of that process. And sometimes there is a clear link with actions that aren't necessarily conducted within the workplace, but they might happen outside working hours as well. And again, that's why questions around, does it genuinely impact the business or its culture? That's why those kind of questions can come into play with that kind of conduct as well. So in terms of behaviours that could constitute misconduct, it would be behaviours that impact the workplace, your businesses, the employer's reputation, or again, they contradict regulatory standards that you have to uphold within your sector and with your area of specialism. So some of the examples that we commonly deal with as well are areas around social media misconduct, criminal activity, and again, interpersonal issues between colleagues. And there are three quite common, probably more so the first, I would say, more common issues that can bleed into the employment arena as well. With regards to the Financial Conduct Authority stance on non-financial misconduct, again, it's good to understand that non-financial misconduct can indicate that an individual is not fit and proper to perform their role. Now, there's synergies here within even the legal profession in terms of, are we fit and proper people to be officers of the courts, officers of the law? And again, we don't want to be bringing the profession into disrepute. And I can see there's natural synergies between the areas that we work in the legal sphere and yourselves. So again, it's not just about the conduct, it's the impact it has within industry, within sector, and again, within the regulatory framework in which you are all subject to. And the FCA expects really high standards, and quite rightly, of behaviour from individuals in regulated roles. So personal misconduct that undermines trust in the firm or in the business can call into question an employee's ability to uphold ethical standards. And I think that is a key area here in terms of some employees may say, oh, what's it got to do with the workplace? Well, sometimes there are issues around how you've conducted yourself and brings into question whether or not your ethical standards are to the standards are expected. And your general character as well. So again, these are aspects that we really need to take seriously and ensure that we address them in the appropriate way. So what I thought might be helpful is to go through a few cases, because I think sometimes nothing brings a legal concept or principle to life more so than a live case. So again, in respect of, that's coming next. I can see that I'm ahead of myself. But before we get on to the case studies, there was a Financial Conduct Authority survey on culture and non-financial misconduct. And they published their findings, I think it was in October last year. And again, it sent a wholesale survey within the sector to understand just where, as a business or an organisation within sector, how the culture was. And again, there were some really interesting findings in terms of culture within the last 3 years. So they found that a number of the reported non-financial misconduct incidents had actually increased over the last 3 years. The distribution of non-financial misconduct types varied by sector as well. And again, firms identified incidents through reactive routes such as grievances or similar formal processes, and through alternative reporting routes such as whistleblowing. So again, it's good for you to understand that within any business, or there should be within any business or organization, there will be different routes to identifying what particular issues are. And whistleblowing, or the whistleblowing policy, grievances, or anything to deal with harassment again, or disciplinary action as well, or disciplinary process, these are all areas that can bring about an understanding or flush out issues that need to be addressed in the right way, that can deal with cultural change required within an organization. And again, in terms of disciplinary or other actions that were taken, there was 43% of cases in that respect as well. And some of the types of the reported non-financial misconduct often resulted in disciplinary action compared to others. So what that means is that maybe there were discussions that were held or investigations carried out, but again, disciplinary action could have been taken instead of just leaving it as it was, or an informal kind of action. And again, the total number of confidentiality and settlement agreements signed by complainants fell over the 3 years. So that trend might either suggest that businesses are tackling these things head on and don't want to just, not necessarily sweep it under the carpet, but are quite happy to go through a full-blown process and stand by a decision to dismiss or to issue a final written warning, whatever the outcome may be, rather than go, do you know what, we're not happy with this conduct, we're just going to try and get this all mocked up through a settlement agreement where no one will talk about it in any event. So again, that's quite an interesting trend and statistic there. I can see people even submitted. Again, discrimination had the highest percentage of incidents resulting in the complainant signing either a settlement or confidentiality agreement. I'm not surprised about that statistic, to be honest. In the last 3 to 4 years, I would say discrimination claims have absolutely skyrocketed. They are far more common in terms of employment tribunal claims that we deal with here within the firm. What we've also noticed is a big increase in multi-claims rather than just a single claim. And what I mean by that is it would be ordinary practice or ordinary statistics that you would receive maybe just a straightforward unfair dismissal claim or a breach of contract claim or a holiday pay claim. What we are now seeing are really multifaceted employment tribunal claims that are coming out in respect of harassment, discrimination, direct discrimination, indirect discrimination, failed to make reasonable adjustments, and we've seen an increase in particular around disability discrimination claims and sexual harassment. So again, this would tend to suggest that either there are higher issues within businesses that are now being tackled or not tackled appropriately, and they're not. And it would also make sense if there's a decline in settlement agreements, then employees are deciding, well, we'll take this further as well. And again, in terms of relevant policies like whistleblowing and disciplinary policies, not all firms surveyed had them in place. So what I would say by way of a learning point is that anyone is sitting in on this call or the session isn't aware of a whistleblowing or disciplinary policy, there should really be one. So I would highly recommend that that's something you bring back to the business and say, where is this? Why have we not got one? And it's probably something that we should have in place going forward. I say that for 2 reasons. One, if there is a genuine disciplinary issue or whistleblowing or a public interest disclosure, you want to know that there is a particular process that will be followed that is consistent across the board. You're not fudging it. You're not guessing your way around it. There is a prescribed way in which you will deal with that. Secondly, it's also a really good opportunity to ensure that you are leading by example. You're setting the tone of what you are like as a business, that you take these things seriously. And again, that has a genuine impact on your culture, your accountability, and your general workforce. I think when you hold yourself to a particular standard, that really does boost morale in a particular way, and it boosts confidence that you will address these things properly. So again, highly recommend that if there isn't these policies or there aren't these policies in place, it would be highly recommended that you get them in place and help with that if needs be. So like I mentioned, I was a little bit ahead of the curve. We were going to talk about some case law examples. So the first one is in respect of harassment, Mordrowski versus Guys and St Thomas. We've put the case citing there, or the citation there, should you wish to have a look up on the internet as to what the full judgment and the facts are of this case. But again, the basic facts around this is that this employee, Mr. Mordrowski, was formerly employed by St Thomas's NHS Trust, and he claimed that he had been bullied by his manager, which he claimed amounted to harassment under Section 1 of the Protection from Harassment Act 1997. Now, the reason we've chosen this case is that harassment claims are usually brought under the Equality Act on the grounds of some form of discrimination in terms of harassment linked to a protected characteristic, could be age, race, sex, disability. But this wasn't in respect of a particular characteristic that was brought under the Equality Act. It was brought under the Protection from Harassment Act 1997 instead. And again, it was held that the trust was vicariously liable for the tort committed by the manager. So the manager's conduct in respect of how they treated Mr. Mordrowski was the issue here, but the business was held to be vicariously liable for the actions of that manager. And whilst the trust appealed, it was found that the employer could be vicariously liable in damages under the 1997 Act for a course of conduct by one of its employees that amounted to harassment in breach of Section 1 of the Act. Don't want to go too legal on it because that's not the purpose of this, but the high-level take-homes that you need, or high-level summary take-homes that you need to take back, is that if there's not a protected characteristic necessarily relied on by an individual, they can still raise a claim under Protection from Harassment Act in respect of a manager, that the business, the organisation that you work for can be held to be vicariously liable. So again, that's your key take-home in respect of that. In regards to the next one, this is about inappropriate social media activity. What I will say is that we are seeing lots of cases, not necessarily around social media activity, but social media platforms, how we communicate with colleagues. I would imagine a lot of us have maybe some WhatsApp, we have texts, we have Facebook Messenger, maybe all other forms of Teams messages. This form of communication is more often than not now used as evidence for harassment claims. There will be screenshots, there will be things that are saved. And I always say as an advisor, if it's not something you want aired in front of an employment tribunal judge, for whatever reason, you shouldn't send it in the first place, because that is something that an employee could ask for under a data subject access request, or be entitled to as part of full disclosure in an employment tribunal claim, or any other court case for that matter, if they want to raise a claim and they need that evidence. So again, the bar is, if you don't want it seen, don't send it. Okay, so this is quite a well-known case within the legal community. This is Higgs versus Farmers School, and again, it was a decision from the Court of Appeal from earlier this year. So the details of this is that the individual, the claimant, was a secondary school administration assistant, and a work experience manager was dismissed following a parental complaint about her social media posts. Now, the claimant in this particular case held a really strong, had strong Christian beliefs and believed biological sex cannot be changed. Now, obviously, we've just had the Supreme Court judgment rule on this for Women Scotland as well. So this is a really topical area at the moment, which is, I would say, very highly emotive. It's not straightforward. But again, the claimant held strong Christian beliefs and believed that biological sex could not be changed. So the posts that were put up were critical of the school's sex education regime. And again, there was reference to gender fluidity and the equality of same-sex marriage with heterosexual marriage as well. And the school interpreted these posts as hostile to the LGBTQ community and reputational risk of the school. And the claimant was dismissed on the grounds of gross misconduct on account of the posts that she had put up. So the employment tribunal held that her beliefs were protected, but the Court of Appeal was successful in a few regards. So firstly, the Employment Tribunal held that she had been dismissed because of these beliefs, but because of was not dismissed because of these beliefs, but because of the school's concern that she might be perceived as transphobic or homophobic. But when it ended up in the Court of Appeal, the court concluded that the school's decision to dismiss Mrs. Higgs was discriminatory because of her beliefs. So the court accepted that the claimant would not have let her views influence her work, that she wouldn't have said anything at work or at the time. And again, she didn't share those beliefs with the students or with anyone else within the organisation. And there was no evidence that the school's reputation had been damaged. So not that it could have been, but that it had been damaged. So the court also found that the post did not primarily intend to incite hatred. And although they were hyperbolically expressed and questionably used offensive language, they were not in the circumstances grossly offensive. So what was considered to be a relevant factor was that some of the posts were reposts of other messages, so not necessarily her own work, and it contained words that on reflection she did not agree with. So again, what I would say is that this is a really good case to show that employers must not jump the gun in respect of decisions to terminate employment based on behaviours outside of the workplace. And again, they must be treated carefully to seek advice as well in respect of that. I will touch upon the Supreme Court case at the end of this session, but I think what this demonstrates is that the Equality Act has competing protected characteristics at times, and it's not a very straightforward area to navigate in respect of what action do you take, should there be any action taken, if so, at what level does that sit, what would be sensible. And, you know, a lawyer's favourite phrase is always, you know, you have to take on a case-by-case basis, and that is absolutely the case here. So whilst you could understand maybe why the school took that decision, you can see from the Court of Appeal's decision, it's not as straightforward as someone put up something on social media out with, you know, the working parameters, was dismissed, and there could still be a finding that that was an unfair dismissal as well. Okay, or harassment. So again, the other things in terms of the practical implications for you in respect of that case is that it's possible that you could see more challenging workplace interactions. That is likely to happen, especially in light of the recent Supreme Court judgment and also the interim guidance that's been issued from the EHRC. So employers, you might need to re-emphasize the need for appropriate and respectful conduct within the workplace. That is your foundation. There is no one right that trumps another, quite frankly. We all have a voice. We all have an opinion. We all have probably protected beliefs and opinions that need to be dealt with and addressed in the right, appropriate manner as well. And again, you need to re-emphasize your commitment to an inclusive workforce and to ensure that your policies and practices are robust in that regard as well. Like I said, no right, no protected characteristic trumps one more so than the other. So again, you've got to be mindful of that, not just in your paperwork and your policies, but also how you address any particular complaints or grievances in respect of these issues. And again, it's going to be probably more challenging to take action against employees for statements made on purely personal social media accounts as well. But again, I would thoroughly recommend that if you are in this situation and you just don't know where to navigate yourself, you make sure that you get the right legal advice in respect of that, because there are PR and reputational risks attached with getting this very wrong. So again, that's just something to be mindful of. So again, factors which would make disciplinary action more likely to be objectively justified would include an objectionable statement being made in a work environment. Again, if there's evidence of a higher chance of reputational damage to you as a business as well, that's something that you can factor in. And if there's genuine risk that the views expressed are likely to influence the employee's work or interaction with others, that is something that you can take into consideration as part of it. And again, if there's evidence that the employee in question has expressed or demonstrated concerning behaviour, that is still something that you can address as well. The manner in which they conduct themselves is just as important as the substantive element of what they say or what they communicate. And again, if there's a lack of insight as to the effect of the employee's actions resulting in a lack of confidence, that you as a business or an employee can prevent more serious or damaging conduct in future. So if they're quite flippant, they're not particularly remorseful, they stand by it, they're not willing to be inclusive in terms of their own outlook to other employees or how they engage within the workforce, that is something that as a business or as a manager dealing with any investigation can take into consideration as well. So I think that makes it quite clear. It's not a straightforward area. It is very challenging. Managers in particular do struggle with this now, because we often find managers might get promoted through the ranks because of how great they are at doing the day job. But managing these employment relation or HR issues is complicated and it is challenging and it's not straightforward. So again, if you have your own HR internal teams, make sure you are touching base with them to make sure that you are guided in the right way. If you don't have that, you should push for external support, in my opinion, because it's not something, like I said, that you want to be dabbling in, because it's these are the kind of cases that do hit the headlines, that do get press attention. We see it all the time in news at the moment. So again, you want to make sure that you're in the right place to deal with it at the right time. The next case that we're going to deal with, or example, is around criminal conduct outside of work. So this was John Frenchen and in the upper tribunal. So for this one, so what happens, for example, if one of your employees is arrested for violence? So again, I'm not saying that we have a lot of this, but there have been more issues around criminal conduct or criminal convictions, either disclosed or not disclosed. And how does that sit? How do you deal with that? And it's, again, it can be challenging. So again, in this particular one, for criminal conduct outside of the work, the FCA issued a prohibition order to Mr. Frensham in March 2021. And he had a criminal conviction for attempting to meet a child following sexual grooming. So again, I think the key thing here for me around this was that he had a conviction for attempting to do this. So there was a finding in that respect. Now, the FCA issued a prohibition order to Mr. Frensham on the basis that he lacked integrity as a result of his conviction, notwithstanding that he did not commit the offence at work and it did not involve dishonesty. I'll let that sink in a little bit. And then Mr. Frensham referred the FCA's decision to the upper tribunal, claiming that the FCA had wrongly applied the fitness and propriety test. And now, while the upper tribunal upheld the FCA's decision to impose a prohibition order, it was critical of certain aspects of the FCA's case and reasoning. The upper tribunal considered that Mr. Fresham's conviction was by itself insufficient to reach a finding that he lacked fitness and propriety, and it criticised the FCA for too readily linking his misconduct outside of the office to the conclusion that he lacked fitness and propriety to perform his professional role. But notwithstanding this, the upper tribunal agreed with the outcome, determining that the FCA, on the basis of Mr. Fresham's conduct after he was arrested and charged, including his failure to be open and transparent with the FCA and his breach of bail conditions. So in a nutshell, the prohibition order was upheld, but there was a suggestion that because of it wasn't enough that there was a conviction. Even for the subject matter of the conviction, which I find quite surprising, if I'm being honest, if I can say that. But especially when they say that that was insufficient. So what that says to me is that if there are criminal convictions, what is it about that links to a finding that he lacks the fitness and propriety to carry out the role? Because then they say that they linked it to the failure to be open and transparent with the FCA and his breach of bail. So the fact that they upheld it because he wasn't open and transparent with them about the breach of his bail conditions, more so than what the conviction was for, I find that interesting. But yeah, I think the main point about that is that if there is a prohibition order, how you want to deal with it, then again, it's about linking why the issue concerned or the conviction concerned directly links to their character and a finding of whether or not they're fit and proper to conduct the role. You can see, just looking if there's, all right, so I was just looking at the chat function, but please add your questions to the chat to cover in the Q&A. Okay, fine. So mindful, I've got quite a bit to still go through. Again, in terms of responsibilities and strategies to help protect business interests, again, make sure you incorporate the FCA guidance within your own employment requirements and policies. Include conduct clauses in your employment contracts. Implement clear policies on off-duty behaviour. We make sure that we have that covered in all our clients' policies and procedures. So it's very clear that their conduct outside work, if we're going to rely on it, and how we'll deal with that internally. And again, provide training and clear communication as to what the expectations are in terms of conduct, behaviour, both inside and outside work, and why it could cross over at times and have an impact on your continued employment within a business as well. And again, in terms of handling misconduct, you have to do this fairly and transparently. Make sure you do it in a timious fashion as well. There's no point, we sometimes get calls saying, we found out about this 3 or 4 months ago, but we didn't do anything about it, but I think we want to do something about it now. I don't like that. My view is if you find out something that you should act on it there and then. If you wait 3 or 4 months, I'll naturally ask the question, why are you waiting now? What is it that's triggered you to want to act now? So I don't normally, I'm not a big advocate for that kind of approach to conduct. If you've got an issue, deal with it there and then. Make sure you follow the code of practice on disciplinary grievance procedures. If you don't know what that is, you should if you are dealing with disciplinary grievances. And I've put there, conduct a thorough investigation. Employment tribunal claims can be lost on a bad investigation, quite frankly. So you need to be clear on how to conduct that properly, who you're speaking to, what the policies and procedures are that are relevant to the process. Make sure it's thorough, make sure it's fair, make sure that you are not the one making the final decision. You're just saying as the investigator, there's enough here to take it to a disciplinary hearing, or there isn't anything, we're not going to take it any further. That's it. That is your remit as an investigating officer. The disciplining officer will need to decide whether or not there's any further investigation to be carried out, be clear on what the allegations are, be clear on what the outcome of the process would be, and stand by a decision that they make in respect of any disciplinary action, whether that is summary dismissal, dismissal with notice, final written warning, first warning, whatever it could be. And again, make sure you carefully document all decisions so that you understand what the allegations were, what the investigations were, what the findings were, and what the outcome is. And make sure you offer the right of appeal as well. I'm really skimming through what is a very involved process right now. And again, seek legal advice. I would always say that, especially if it's going to amount to dismissal or summary dismissal or acts of gross negligence or gross misconduct. The stakes are higher, so employees are more likely to challenge that because you're not, and it's reputation. To them, it's pride. So again, they're more likely to challenge decisions like that in an employment tribunal. So in terms of conclusions on non-financial misconduct, it can be damaging to the business reputation and again, time spent. And again, there are cultural and sector-specific expectations as well, so make sure you abide by them. And there's got to be a balance of freedom of expression with reputation. That's fine, completely get that, but you need to set your stall up from the outset as a business as to what you will and will not accept by way of conduct, how we communicate, how we treat others within a business. Everything has got to demonstrate that you are still inclusive and respectful to everyone within the business and you're not taking sides, as we should say. And again, make sure you proactively manage risk through training, policy and culture. What I mean by that is it's all very well having your policies and procedures, but if you don't act on it, you don't rely on it, then they're not worth the paper they're written on. Secondly, if you see any bad behaviour or anything that you think needs to be addressed, hold people to account, report it. Again, that demonstrates you've got the right accountable culture within the business. And again, make sure decisions are proportionate, in my view, and consistent. So if there is something that you are dealing with and you're dealing with it differently and there's been situations where similar circumstances have taken place and you are taking a completely different view on it, that is a risk for you as a business. You would have to be able to differentiate why you are not, say, dismissing someone or not issuing a final written warning when someone last week who did exactly the same thing didn't get that sanction as well. So again, you have to be consistent. If you don't, it's another arm for an unfair dismissal claim as well. So I really glossed over, in my opinion, what full disciplinary process would be. That's a session in itself. But the purpose of this was to highlight how cases can be dealt with, how non-financial misconduct is a genuine, active matter that must be dealt with in an appropriate way, and how it can impact you as a business as well. The next area that we're going to go through is the Employment Rights Bill and the recent Supreme Court decision. Now, I was just saying to Alison before joining this, I was asked to comment on this, and I was on BBC Scotland on a podcast on Monday about this. And if you listened to it or if you watched it in the evening, I don't know, what I will say, it might sound as if I've given quite generic, bland, not particularly practical or helpful advice. But the reason for that is that we're none the wiser either, to be honest, as legal advisors. We are still waiting for the guidance, the full guidance, which will still need to be voted on and backed by government and politicians around what does this mean for businesses. Now, for those who aren't aware of this, this was the For Women Scotland case around what is a woman, and the Supreme Court decided that a woman is in respect of someone's biological sex, not the gender in which they choose. So again, for the purposes of the Equality Act, I should say. So again, it's been an interesting and highly emotive topic of conversation across the board. So we'll touch on it at the end, but it was just in case no one. So in terms of the Employment Rights Bill, a kind of summary of what that is for those who weren't in the last session. The Employment Rights Bill is a whole suite of proposals that the Labour government have put forward by way of employment legal reform. And it's aimed at modernising and updating employment law. And it's at the committee stage in the House of Lords, and it will be going through those various stages. I'm not going to go into the details of that, but again, it's not yet in force, and it's not likely to come into force until 2026, so next year. So what we're doing with all of our clients is making sure that we're keeping them updated as and when things do progress, or if there's any little bit more information around some of the proposals. But what we've noticed is some things haven't been included in the next round in terms of the bill. Things like the right to disconnect, equal pay issues, workplace pay gaps, the reconfiguration of rules around employees and workers, parental leave, carers leave, and TUPE, the transfer of undertaking, protection of employment. So we'll go through some of that as well, but just going in terms of what I would say the top 5 picks are, because that is what's getting a lot of attention. So obviously we know now about the day one right to claim unfair dismissal. We currently operate on a 2-year continuous period of service before someone has an unfair dismissal right to claim. That's being proposed as being removed, and there's going to be what you call an initial period of employment, which would be 9 months, like a 9-month probationary period, where you could have a different kind of process to dismiss someone so that you don't necessarily fulfill the unfair dismissal regime. But again, that's not been hugely popular, especially for the SME or in a managed business market. So again, that's something that everyone's really keen to understand how they think that's going to work. There's areas around 0-hour contracts, and again, the right to move to a guaranteed hours contract after a 12-week period. Again, that's something that's being pushed forward still. The fire and rehire, that's a huge area of concern, I think, for businesses. At the moment, you've been able to dismiss and re-engage employees once you've tried to push through some changes in terms of the contract. So that could be, I don't know, it could be notice periods, it could be restricted covenants, it could be just general T's and C's that needed to be adapted or changed. Normally, if people don't agree after a period of time, you dismiss, you'd offer up a new contract and say this is engagement. They're saying that unless there is imminent financial instability or risk, you can't do that. It would be automatically unfair. I think this is a huge area of concern for businesses. And again, in terms of trade union rights, we can see that there has been an enhancement around that as well. So again, for any of you here who either recognise or have unions involved, that's something that I would recommend that you keep on top of in terms of how that's moving through the legislative system. And again, flexible working, that at the moment is a day one right to request flexible working, but what the proposals are saying is that the default position will be to be able to work flexibly. And if you reject a flexible working request, the grounds on which you reject that and the refusal must be reasonable. So there is more onus on businesses to really explain why they are rejecting it. To simply say it's not worked, it never will, we're not willing to do that, is not going to fly going forward. So again, not enforced. None of this is enforced right now, but again, it's just to make you aware that that's what's on the horizon. Again, what's in, I'm not going to go through all of that in any detail because it's just a list of everything that at the moment is still in. And I think it's important for you to be aware of what they are because they're not going to go anywhere. So again, we've got the day one rights, the SSP, bereavement leave, protection against sexual harassment. Again, that's from third parties coming into play as well. So that is something to be mindful of. And again, make sure you're getting the updates. If you're not getting updates on this and you would like to, we send out updates regularly. So again, if you want to let Alison know that you want to receive them, we'll get you on our distribution list and make sure that you get all these updates because a lot of our businesses and our clients are wanting the updates as and when they come up, and that's something that we're really doing at the moment. In terms of collective consultation, I wanted to touch upon this. So collective consultation regime, there is a prescribed process that you need to go through that if you're likely to make dismissals or redundancies that are 20 or more within a 90-day period, you have minimum consultation requirements and periods before you effect any dismissals, which are either 30 or 45 days, depending on how many you're making redundant or dismissing within the 90-day period. So the thing around that is that at the moment, we've been able to do that on a site-by-site basis. So it doesn't matter. You don't need to, if you're a national business, need to take every employee involved into consideration. If you're doing something in Glasgow, or you're doing something in London, or you're doing something in Liverpool, wherever it may, they're all different entities or establishments, I should say, for the purposes, and you don't normally hit the 20 number. What's being proposed is that you would lump every business on a national scale to understand what the establishment point is. But now there is some reform around that saying you only need to do that if it's related. And if it's not, then you could maybe still do a site-by-site basis. But again, it's something that we're still very much kind of trying to keep on top of at the moment. In respect of, I mentioned this, so this was the For Women Scotland Limited. It's worth touching on this because as I mentioned, it's made clear that for the purposes of the Equality Act, which has all the discrimination claims that employees have the right to raise, so I'm just going to change that. They've made it clear that for the purpose of the Equality Act, sex refers to biological sex. So it doesn't matter if as a transgender individual, if you are a trans man, trans woman, the purpose of the Equality Act, you would still need to refer to your biological sex. Now, I think that's going to be hugely problematic within businesses and managers to kind of identify. And I don't want to reduce it all down to toilet facilities, but that is what has been the topic of conversation. What are you meant to do when a trans man goes into a male toilet? Are you meant to say they can't use or they can use those facilities? And the answer at the moment, from a legal perspective, is that technically you're meant to deal with it on a sex basis, but practically what we're seeing is that most businesses aren't going to change how they deal with anything until there is maybe a problem and something is raised, and then they deal with it accordingly at that point, because I don't think some employers want to necessarily rock the boat when things aren't a problem or aren't an issue anyway in terms of how they carry out their own practices. But again, please be mindful of this as well, because it is a really challenging area. And what I would say is that whilst the EHRC has provided interim guidance, there is some commentary around that not necessarily being as clear as it should be for businesses. And again, there is due to be guidance published, I think June time, but it's going to be subject to a period of consultation before it comes out. So what I would say is if you are in any forums that you want to contribute to that consultation process and engage in that discussion, and engage with any concerns you might have around this, make sure you get yourselves involved in some particular way as well. So I'm not going to go into the nitty-gritty around that, because I think I've provided you with a summary of what the issues are. So the main thing to kind of disseminate from that is to make sure you look out for the update that is coming out from the EHRC. Because at the moment, for the purposes of the Equality Act and discrimination claims, a gender recognition certificate isn't going to change the way in how sex is determined under the Equality Act. Okay, and we've got some literature there where you'll all get a copy of these slides, so that's why they're more detailed, because I wouldn't necessarily go through all of that. But again, it is just something that you might want to read up yourselves. So what I will say is that the issues and concerns for transgender people and the transgender community is that there's things around policies, employers, and the effective areas. So again, we need to consider, do we need to review policies regarding single-sex spaces in the workplace? What I should say is it's not just under the Equality Act. There's I can't remember the name of it, but there's a 1992 regulations that do stipulate that you are meant to have single-sex toilet facilities. But I think the way to move forward might be to have gender-neutral spaces and toilet facilities. Again, I was in Denmark a couple of weekends ago, and we also went over to Sweden because it's so near and you can jump on the train. And this wasn't an issue. Every space that we went into was a gender-neutral facility. So again, is it a case that we need to move to that kind of format within the UK? I don't know. But again, it's just businesses are trying to grapple with how best to kind of address this going forward. And I think we just need to wait to get the full guidance from the EHRC to really understand what the requirements are here. And there might still be some movement around as a result of this judgment. There might be a move to change the Equality Act to deal with something. I was asked the question whether or not we think that reasonable adjustments might need to be made for particular members of the community as well. I initially said, no, I don't think so, because reasonable adjustments is not more synonymous with, those that are disabled under the Equality Act, and whether or not that would be the right terminology for the trans community. I didn't think it would be, but again, I could be wrong. There might be something around reasonable adjustments that might need to be made that, again, might come out at some point. But again, it's not a straightforward area. It's highly emotive. It's a really complicated area. And again, we'll just keep you updated as and when. But again, if you want to be updated on that, we've got a lot of material and literature on that as well. At the moment, we can obviously do that. So yes, I think the main thing here is that we want everyone within the workplace to feel inclusive. We don't want them to feel isolated or uncomfortable in any way. And that is the key message that I'm driving home as not just even as a legal advisor, just as a human being. Like we've all got to live together. We've all got to work together. And what is the best way to make sure everyone feels included in the right possible way? And I think it's a really, it can be a challenging area, and might be a challenging time. But again, we'll just have to wait and see what the EHRC guidance comes out and says, and hopefully it supports with clarity as well for businesses. So I'm conscious that it's 10 to 2. I have talked to you all, and I have not seen a hand, I don't think, or a question inserted into that chat box. So I will either assume that this all makes absolute sense and you're all happy with it, or I've just spoken at you and I've made you all lost. So I'm hoping it's not the latter. So if there are any questions, I'm more than happy to take them on board. And again, we've covered quite a spectrum in a very short space of time, quite frankly. But again, if you need any further updates or further discussion around any of this that I've discussed today, more than happy to do that offline. And again, I will send Alison a copy of these slides. And also, if you want updates, I'll give details on how to do that as well. So over to you, Alison. I hope that was okay for you all.
Thank you very much. That was, yes, really insightful. And as you say, there's a lot of information there to digest.